The 20th century began as a time of great hope, as the Industrial Revolution and modern technology transformed the world. However, all that changed with the coming of the First World War, which upended the world order. After the war ended, many nations, especially in Europe, experienced great social and political change. Monarchies and empires fell, and new democracies, and in some cases, autocracies, emerged. In the United States, little changed politically, but great fear swept the nation because of the changes in the world, especially related to the rise of communism in Russia. Across the nation, communities began to push for laws to curb foreign influences and limit immigration. One such law was proposed in Oregon, which required all children to attend a public school, where it was felt they could be adequately Americanized and kept safe from foreign and especially communist influences.
I'll get it. Coming. Charles, come in, come in. How are you?
I'm well, thanks. Thank you so much for having me over for dinner.
Let me take your hat. Come into the dining room.
Hello, Jane.
Hey, Charles, it's great to see you.
Have a seat at the table. Dinner's almost ready.
I see some fools who put this school issue on the ballot. Surely Oregon is better than this.
Oh, Charles, you always were so open-minded. But you know times have changed, and we have to protect our children.
Come on. First off, neither you nor I have children, so this isn't even our place to speak. I mean, I just think if parents want to send their kids to a Catholic, Adventist, Episcopal, or whatever other kind of school, they should be able to.
Yeah, but who knows what those schools are teaching? I heard some of those religious schools are teaching radical ideas.
Radical ideas? You call teaching church values a radical idea?
Papist values, if you ask me.
Come on. You really think these church schools are going to fill these heads of the children with a lot of mumbo jumbo?
Probably. All I know is if we keep our kids in a public school learning the basic laws of the land, then they're not going to be influenced by these outrageous points of view.
Okay, Henry, you're getting really out of hand here. I'm gonna have to cancel that one subscription to the newspaper. Even I know that's absurd.
Yeah, come on. Catholic and other schools supporting radicals? The same ones who want to shut down their churches? You've got to be kidding me.
Okay, let's change the subject. Politics never was a good point of discussion for us all. How's your mom?
Doing well. Still working as a librarian over at St. Benedict's School, making sure all those books are sufficiently radical.
A well-coordinated strategy throughout the state put the issue on the ballot, and both sides began campaigning. The school bill was supported by some well-meaning people in social groups, such as the Masons, but it was also supported by nefarious groups, such as the Ku Klux Klan, who were known for their racist, anti-foreign, and anti-Catholic ideologies. The debate over the school bill raged in Oregon and grew more contentious as Election Day approached.
Mr. Smith, my name is Sarah Donald from the Oregonian. Do you mind if I ask you a few questions regarding the mandatory public school initiative?
Well, of course, go right ahead.
Well, it's clear that this support has been really increasing over the past few weeks. Why do you think this is the case?
Well, Sarah, I think that any reasonable parent wants nothing but the best for their children. The goal of our initiative is simply to make it law that children ages 8 to 16 receive a quality public and American education. There's nothing crooked to hide here. It's just a simple push to pursue better education standards.
And some would argue that the state is actually overstepping its boundaries by forcing parents to send their children to a public school. What would you say to those individuals?
Well, I would consider that argument rather fruitless. Remember, this is the same government that has the authority to draft and send our young men to war. Sending our children to quality academic institutions is certainly far within their boundaries.
Well, thank you very much.
Any more questions?
That's all I need. Thanks again.
Thanks.
Oh, Father O'Hara, my name is Sarah Donald from the Oregonian. Do you mind if I ask you a few questions about the mandatory public school initiative?
Oh boy, do I have much to say about this. Go right ahead.
I'm sure you do. You oppose the initiative, saying that it's simply about pursuing better academic standards for the youth, but you also say there's more to it than that. Do you care to elaborate?
There's much more at stake here, Sarah. If you read my pamphlet, Freedom of Education, I argue that parents maintain the primary right and obligation of educating their children. The state has no right to interfere.
And why do you say the state has no right to interfere? I mean, they can send our boys to war, so why can't they regulate education?
Well, if we want to contrast this initiative to the basic fundamental values of freedom, my argument becomes clear as day. In fact, my opposition to this initiative centers around freedom. What free country openly decides to grant the state power to drag children from their homes and force them to be educated wherever the state decides? That's ludicrous. And as for your comparison to sending young men to war, that's done in a time of great national emergency. No such emergency exists at this time.
So do you think there could be an ulterior motive backing this initiative?
Of course. This initiative is about broadening state control and denying people, especially immigrants and Catholics, their liberty. Suppose the state wins and gains control over how all children are educated. What comes next? The state gets to control what doctor we go to, what religion we're permitted to practice.
Well, you make some bold points, Father O'Hara, but I have everything I need. I appreciate your time.
It was my pleasure. Have a good day now.
This is a KMED Radio News update. The initiative to institute mandatory public schooling has passed. With a margin of nearly 53%, the initiative is now set to become law. However, there is expected to be serious pushback within the court system, so we will keep you updated as more to this story develops.
I cannot believe this. 53% of our own people openly chose to rid our state of freedom? This will certainly not be the end, and we'll do all we can to fight this in the courts.
Do you think you have a shot?
Sure hope so.
Many people throughout the state reacted with horror, especially those involved in schools that would be forced to close. One such group was a group of nuns, the Society of Sisters, which ran St. Mary's Academy, a school for children. Like many, the nuns were worried as they knew the law would spell certain doom for their school.
Sister, you won't believe what happened today. I walked into my classroom and there were no children.
You mean there were none?
This is serious, Sister May. Numbers all across the state are dropping in Catholic schools. I myself have seen this. My class only has a few students remaining. Even at that, they don't want to learn. They just keep asking questions about what's going on and where all their friends are. We're short on numbers again today. You'll all be going to college soon, and if your friends don't come back, they won't be ready. We started this year off with 15, and now we're down to just 2. What happened to Jim, Bob, and Cindy? They were all here yesterday.
Bob and Jim told me yesterday that they were going to the public school, starting today.
Yesterday, Cindy didn't know what was going to happen. She said her parents have been arguing a lot lately and talking about school. Maybe she's just sick.
I don't think Cindy is coming back.
I don't think anyone is coming back.
This is a tough time for our school.
I miss everyone.
Me too.
I know you do. I miss them too.
Wow, their hearts are broken, and there's barely anyone left. It is really quite sad.
I honestly don't know what to do anymore. It's as if this country is turning its back on the Lord. Before we know it, we may be out of work. Oh, I pray for the youth of this nation.
I pray for everyone in this nation, sisters. What's happened to your school's a tragedy. Even worse, it's illegal. When will we draw the line on government power?
Father O'Hara, please tell me you have a solution to all of this.
Oh, I do. This here's J.P. Kavanaugh. We just had a long conversation, and we both believe the Society of Sisters has a case against the state.
That's great. There is a chance to save our schools. The Lord has answered our prayers.
Do you believe this, Governor? Society of Sisters to bring school bill to court. What nerve? Don't they know the people of Oregon have already voted?
Calm down now. Everything's going to be fine. Judges are like putty in my hand. This will all be wrapped up in no time. Besides, the bill is within the law and has been approved by 50% of our people. Those sisters are in for a fight.
A fight? Governor, don't you think it's a bit uncivil to fight a group of nuns?
Not an actual fight, you fool. A fight in the court of law. These sisters are through preaching their anti-American propaganda to our children. Don't you see that this is about more than just this case at this time? This case is about the future, and I'm willing to fight for that future. More importantly, I'm willing to fight for America.
The sisters decided to take the case to court, alleging, among other things, that the law violated their property rights as a corporation and the rights of parents to decide how and where to educate their children.
So just to be clear, Mr. Kavanaugh, You are resting much of your case on property rights, correct?
Yes, we contend that the law violates economic liberty interests, such as property rights secured under the Due Process Clause of the 14th Amendment and secured under the Lochner decision. In essence, this law deprives the sisters of their livelihood to operate the private schools and deprives the teachers their livelihood of conducting those private schools.
Your Honor, my opponent seems a bit confused as to the relevant case law in this area. The Supreme Court in the 1908 decision, Berea College versus Kentucky, provided precedent for this court to uphold the state's rather extensive regulatory authority and to ignore claims alleging deprivation of property rights.
Now, what about discrimination?
Your Honors, this law does in fact promote discrimination. It was pushed by anti-Catholic and anti-immigrant groups who wish to violate the Free Exercise Clause of the First Amendment.
Your Honor, this law does not discriminate. Quite the opposite, in fact. It makes all equal by requiring every child to receive a quality public education in an American school. And equality before the law in all things, including education, is a hallmark of our American democracy.
Well, thank you to both sides. Now, this court has much to consider and will reconvene tomorrow morning with its decision. The issue at hand here is whether or not the state of Oregon can compel parents to send their children to public schools. We have decided that the state of Oregon does not have the constitutional authority to do so. Now, there is no indication that the private schools run by the appellees are harmful, but rather useful and commendable. Now, it is fundamental to liberty that a state government does not have the constitutional authority to standardize children and make them attend public schools. And for these reasons, the Compulsory Education Act approved by the state is unconstitutional.
With the district court ruling in favor of the Society of Sisters, the state of Oregon appealed the case to the Supreme Court, continuing to contend that the law was a valid exercise of state power.
This court is now in session. Today we hear the oral arguments in the case of Pierce versus Society of Sisters. Ms. Guthrie, please present your argument.
Your Honors, may it please the court. Today, we are asking the court to affirm the lower court's decision that the Oregon law mandating all students to attend a public school is an affront to the liberty which sits at the bedrock of this nation. The supposed reason the law was originally enacted was to promote American values and to assimilate children of immigrants in the face of threats posed by foreign ideals, such as Bolshevism. This would suggest that non-public schools teach subversive ideas, but this is simply not the case. In fact, before the mid-19th century, no public schools were available, and our founding fathers, who were formally educated, received that education in private schools, many of them religiously affiliated. And today, the nation's premier schools are privately run, including St. Paul's at Groton. In addition, the state has the power to regulate and prohibit the teaching of radical ideas in public and private schools, rendering this statute unnecessary for those purposes. In fact, this act does not promote freedom. It violates the principles of freedom. Namely, it violates the school's freedom, the teacher's freedom, the parents' freedom, and the student's freedom under the 14th Amendment's Due Process Clause. It causes harm to the business of schools, which is to educate, and it threatens to render their property and business useless without their customers, that is, the students. The state does not have such a right to violate the school's contract which allows it to operate, as we know from the venerable Dartmouth College case. Finally, I would like to touch on the fact that this case violates the rights of parents to choose how and where they educate their children. as the venerable scholars Blackstone and Pufendorf believed in the venerable rights of parents. Indeed, the state has the power to mandate that a child receive an education, but the power to require education does not come with the power to prohibit that education from being delivered in a private institution. Your Honors, I hope that you can see this act for what it truly is. It's a violation of the rights of schools and parents under the 14th Amendment's Due Process Clause and an egregious overreach of state power.
I have a question. How does your position square with the decision in Meyer versus Nebraska?
We believe it strongly supports the case. Again, this act was passed by legislature in an effort to curb the potential influences of foreign ideals, in the case of Meyer, foreign languages. And this court held that the law was an overreach of state power and an improper use of police powers. As Justice McReynolds pointed out, great men may support these laws, and they may even find support from sources such as Plato and his ideal commonwealth. But the fact is that his support of homogeneous society is repugnant to our American values and Constitution.
Thank you, Mrs. Guthrie. Mr. Moore, please present your argument.
Thank you, Your Honor. May it please the court. Much of my opponent's argument hinges upon the 14th Amendment and the rights contained therein. And although this court has often defended the rights of individuals under the amendment, it has also defended the power of states to enact laws to protect the health, safety, peace, morals, education, and general welfare of its population. And this fact has been supported by this court many times, including in the cases Munn versus Illinois and Mugler versus Kansas. In Munn, this court held that an Illinois law regulating the grain elevators was constitutional, as the operation of grain elevators is done in the public interest. And in the case of Mugler, this court held that prohibition laws were a legitimate exercise of state police powers. I think it's worth quoting Chief Justice Wade's majority opinion in Munn, where he wrote that when property is affected with a public interest, it ceases to be juris privati only. Surely education is an area where public interest justifies state interference. In addition, the private school's rights have not been violated. First, the state cannot, in agreeing to a contract with a private institution, such as a school, give away its powers and rights, which emanate from its power to regulate the health, safety, and morals of its citizens. Plus, much of the opposing argument rests upon the fact that the rights of the private schools were violated, but the private schools have no such rights. The 14th Amendment gives rights to actual people, not entities created by people. My opponent also argues that the statute violates the rights of parents, but this argument should be dismissed. My opponent represents the schools, not the parents. Therefore, she cannot argue in this case that the rights of the parents are violated, as that is irrelevant to her client's case. Your Honors, the facts of this case are simple. The good people of Oregon, observing the threat posed by radical foreigners, decided that the future of the state should be protected by ensuring that all students are given an American education in an American school. I trust you will agree.
I have a question. You assert that the schools do not have rights, but hasn't this court found that corporations have rights? And aren't the corporations, in this case the schools, made up of people who have entered into a contract with the state?
Yes, Your Honor, the school has entered into a contract with the state, but that does not take away the power of the state to enact certain laws. For example, prohibition has not been overturned on the grounds that it deprives the saloons of their customers. Neither should this law be overturned on the ground that it deprives schools of their clients.
Mr. Moore, I'm interested in the issues of the parents' rights.
We would argue that the parents' rights are irrelevant to this case, as those who've challenged the law are schools.
But that still does not negate the question of whether or not the parents' rights are being violated.
We still believe it to be irrelevant.
Okay.
Thank you both. This court is now adjourned pending the final decision. This court is now in session. Mr. Justice McReynolds will read the opinion of the court.
In this case, the court has been asked to consider whether an Oregon law, which provides that all students must be educated in a public school until the age of 16, is constitutional. The appellee, the Society of Sisters, is an organization of Catholic nuns that run a school, among other facilities. It is argued that if this law is allowed to stand, that the rights of the schools and the teachers will be violated, as it will almost certainly mean the sisters will be forced to close the school. It is also argued that the rights of parents and children will be violated. Each state has an unquestioned right to enact laws and regulations to govern the health, safety, and morals of its citizens. Education is a part of these categories and is regulated in Oregon as it is in other states. The constitutionality of these regulations is not questioned. However, the Oregon law requiring students to attend public schools goes further than normal regulations. If enforced as the state had promised it will be, it will certainly cause private schools in the state to close. These schools have shown no deficiency in educating their students, and on the contrary, have meritoriously and sufficiently educated generations of students. There is therefore no reasonable cause for taking away their right to educate students. In addition, under the doctrine of Meyer versus Nebraska, the rights of parents are violated by this law. It is a parent's right to educate their children as they see fit within the bounds of reasonable regulation. By requiring students to attend public schools, the state is taking away from parents principles of liberty that are, according to them, theirs, the Constitution theirs. The child is not the mere creature of the state, and it is the right and duty of the parents to prepare him or her for their future as educated citizens in our democracy. The ruling of the lower court is affirmed, and the law is repealed.
With the Supreme Court ruling in favor of the Society of Sisters, the Oregon law was struck down, and parents were free to educate their children in public or private schools. Although the case may seem to have straightforward implications, it was a seminal case and many legal developments relating to personal freedom. It certainly was a victory for parental choice when it comes to children's education. Today, in all 50 states, parents can send their children to public or private schools, or they can choose to homeschool them. And the case was also a victory for religious liberty. But the case has led to other rights as well. In the latter half of the 20th century, the Warren Court and subsequent courts, mainly using the 14th Amendment's Due Process Clause, found that the Constitution contained a right to privacy and ruled that states cannot enact certain laws regulating certain areas of people's personal lives. This legal development traces directly back to Pierce and other cases of its era, showing that cases decided decades or even 100 years ago continue to have a profound impact on our daily lives in ways that may not be readily evident. Thank you.